SJC-13489, Outfront Media, LLC, v. Board of Assessors of Boston.
Okay, Attorney Fry.
Thank you, Madam Chief Justice, and Your Honors. May it please the Court. My name's Kelly Frey. I represent Appellant Outfront Media. I'm joined by my colleague, Ed Daly. Your Honors, this case turns on the answer to two questions. The first question is whether or not the services contract between Outfront Media and the MBTA constitutes a lease, use, or occupancy of MBTA real property. If it does not, then the Court should reverse the decision of the Appellate Tax Board below, because the MBTA's enabling statute requires the existence of a lease, use, or occupancy as a condition precedent before any tax can be imposed against MBTA property. If and only if that condition precedent is satisfied, then there's a second question for the Court to determine, and that is whether or not the taxes imposed against these signs has more than a negligible impact on the MBTA's ability to generate commercial advertising revenue. If it does, then the Court should reverse for that reason, because this Court found in MBTA versus Somerville that the MBTA's ability to generate commercial advertising revenue is statutorily integrated with the MBTA's essential function.
Isn't this clearly a use of the property?
That's precisely the problem, Your Honor, is that under the Board's definition, any activity at all that touches upon the MBTA property would be considered a use. The Board defined a use to mean any activity that puts the property into service to avail oneself of, to employ, to have the privilege or benefit of using something, or to have the legal enjoyment of property that consists of its employment, occupation, exercise, or practice. That is duly broad construction of the word.
But turning to you,
Right.
you have the exclusive rights to advertise, install, operate, and maintain the equipment, correct?
That's correct.
How is that not a use of the equipment?
It's not a use, Your Honor, for several reasons.
And you get the profits too, right?
Well, I guess that's a big one.
A portion of the profits, Your Honor, the MBTA gets a portion of the profits as well, and and those profits, not only do they get them, those profits are statutorily integrated within the MBTA's essential function. And the reason why is because
We all know the MBTA is desperate for money, so there's no doubt about that. But just back to Justice Gaziano's question, you're using the signs and getting a percentage of the profits.
that's,
It just seems like that meets the statutory definition.
respectfully, Your Honor, it doesn't.
Better help us.
Sure, absolutely, Your Honor. There are several reasons. First, the word use, look at where the word use appears in the statute. It appears in, let me take a step back. It'll take me a while to get there, but Your Honor, you'll understand why I'm taking a step back and talking about the burden and responding to your question. The Appellate Tax Board got it wrong on the burden. It applied the incorrect burden.
Well, you're seeking an exemption. You can argue that, you take up your time, whatever, in however way you want. But I don't know of any case where we have put the burden on the board to show, and anyone other than the taxpayer to show that an exemption applies.
Your Honor, we are not seeking an exemption.
Well, you
Outfront
are,
itself,
because if this was owned by you, you would definitely need to pay taxes. You're saying we don't fall under the exception to the exemption, and so we're due the MBTA's exemption.
Your Honor, the parties have stipulated
That this is real estate.
the signs themselves are covered by the exemption. The parties have stipulated that the
So
signs are
if
covered by the
owned
exemption.
by the MBTA and not used by your client, they would be covered by the exemption.
They are covered by the exemption regardless of whether they are conducted with a business for profit. The question is whether they are leased, used, and occupied in connection with a
And
business so
therefore
that they can
not
be
covered
taxed.
by the exemption.
And so it's the assessor's burden to establish that that condition precedent is satisfied, because that's the only condition. They don't have authority to tax unless that condition is satisfied.
And is this the only tax provision where there is an exemption and then exceptions?
It's not, but this is the only case where this issue has been presented other than Ogden. What the assessors describe as the
So
exceptions.
is it Ogden then? I mean,
Ogden, that's-
who had the burden of proof when there is an exemption and an exception to the exemption?
And we don't know, because the appellate tax board did not
This
set a
is a
standard.
new issue for us.
It is, Your Honor.
Okay, great.
It is, Your Honor. Every single other case, and I want to be clear about this, every single other case that's cited in the appellate tax board decision and in the assessor's brief, the existence of a lease, use, or occupancy was presumed. It was not at issue. Here, the question that the primary question that the parties have briefed to the appellate tax board below and to the court here is whether or not a lease, use, or occupancy exists. On that question, it is the assessor's burden.
I think you need to, I know you want to jump to the burden issue, but the language is so direct. If used in connection with a business conducted for profit, your clients are engaged in a business conducted for profit. You're using the MBTA's signs for a business conducted for profit. You better help me get out of that. And because use is big doesn't get me there.
Well, think about the effect of what that simple, admittedly simple and appealing determination of what the word used would mean. It would mean that a construction worker, a janitor that comes on and cleans the bathrooms.
No, it doesn't say that.
They would, but that is a use. A janitor employs MBTA property.
Property is used. If the property is used in connection with a business conducted for profit, that's different from if you have a janitor there, right? And that's where we get to Ogden, which Ogden's your best bet.
It is.
Because you're really, the statutory language so obviously fits you, but Ogden, the tax board just went a different way. There, I see you may have some traction.
Right. And importantly, Your Honor, that happened just a few years before the legislature added the word use to this statute in 2013. And it's presumed to be aware of how the appellate tax board decided Ogden. And in Ogden, the appellate tax board found that a for-profit service provider who managed an events facility for taxes in public university was not using the facility's property in connection with a business for profit. I mean, what they were doing there, they were hosting WWF wrestling matches. They were coordinating David Copperfield magic shows.
They got a service fee for that, right? It's different from this. You guys are just you're running a profit, you're generating profits off of this as opposed to just getting paid for operating, getting a service fee. A little different, right?
No, Your Honor. In Ogden, there were two different elements of the contract. One was the for-profit company would help the university host university-sponsored events in the facility, and that's what they got the management fee for. And then the separate part of the contract was they would host these for-profit events, like Aerosmith Rock and Roll Show is another one mentioned in the decision. And for those, the for-profit company and the university would split the revenues, and that's the element.
But importantly, the for-profit entities' upside on those non-university events was capped, was it not, in Ogden?
It was capped.
It was capped. So here, though, your client's upside is not capped, right? It has to pay a percentage of gross revenues to the MBTA, but beyond that, whatever profits you reap are yours to keep with no cap.
No, whatever profits we make flow both to the MBTA and to us. So there's a minimum guarantee. So we have to. the revenues have to reach a certain threshold under the contract. But once they reach that threshold, the revenue split goes for infinitely. If we made the revenue split between the MBTA and the Outfront, it goes as high. There is no cap.
Right, yeah, so unlike Ogden, there is no cap to your profit,
And no cap to the MBTA's profit.
regardless, but none to you.
Right, right.
Right,
Yes.
right. And so maybe that's the difference between the type of use that is not a use in Ogden and the type of use which is a use to you. And I'd like to give you the opportunity to respond to that. You have no upside cap to your provision of these services for advertising on the MBTA signs. In Ogden, there was a cap to the provider of the management services.
Right, and the contract should be structured that way, so that Outfront has an incentive to get every dollar of advertising revenue that it possibly can to split with the MBTA. That serves the MBTA's essential function. It serves riders, it increases non-fair
Right,
revenues.
and maybe a consequence of that is that you pay tax.
It
That
should,
might be an advantageous business relationship. I'm not suggesting there's anything nefarious about that. But under the provisions that we're looking at, it looks more like a use.
Respectfully, Your Honor, I think the more critical distinction that the assessors are trying to draw between Ogden is that Ogden paid a management fee and for the private universities' use of the facility. Here, the MBTA, let's not forget the fact that MBTA has the right to use these signs 25% of the time.
They didn't pay a management fee, they received a management fee. Ogden received a management fee, right? They didn't pay a management fee.
I'm sorry, received a management fee for the portion of the time the facility was being used for university events.
And that's
Here,
all they got.
and they got a revenue share as well, just like Outfront does. Outfront just got the same revenue share. The only difference is it's not capped.
So can I come at it a different way? So we know what a lease is, we know what occupied is, right? So now we're dealing with use. And you say the ATB got it wrong, they have this broad dictionary definition of use. How do you define use?
Well, I define it by how the court has defined it for over 100 years of property law. The word use is used in the statute to define a property right. And so why not look to property law to define what would use?
I read a bunch of those cases you cite. They distinguish between a lease and a permit. They don't define use in this context. They just say it's not a lease, it's a permit or a license, right? All those cases you're citing are really of very little import.
Respectfully, they are, Your Honor, because they are the cases
Fine
addressing they are the cases addressing how to classify the right to go onto another's property.
But they define it. It's not a lease, it's a permit or it's a license. That's what all those cases do, right? Is there any case that, I looked at them.
No.
I read all those old cases you're citing.
No, they don't define. They define how the right to go onto another property and maintain a sign should be
They say
classified.
it's not a lease, it's a permit. It's not a lease, it's a license. That's what those cases say, right?
Right, and in every one of those cases,
They don't say
it was either.
they fit the definition of use. They don't fit the definition of use.
I understand your question. Yes, you're precisely right. No one, there's not one directly on point. But what they do is they define the property right as a license, or in the baseball publishing case, an easement. All of these categories of property interest that the legislature did not add to the statute. If the legislature wanted an easement right to be taxed, they would have said easement rights should be taxed. If they wanted a license right to be taxed, they should have said a license right to be taxed. So where this is only a license right that Outfront holds, it shouldn't fall within this, get shoehorned into the term use.
Did you ever say what the definition is?
No.
Yes, it's used to refer to a possessory interest in land is what Massachusetts case law has said. Referred to the use and occupation of land for over a century as a possessory interest in land.
So you're asking us to construe use consistent with the way use and occupancy has been defined in real estate law?
Precisely, Your Honor, because
Okay.
as it appears in the statute, it's being implemented to describe a property right. And so
Isn't it odd, though, that the statute doesn't say use and occupancy? and instead says use, comma, occupation, or whatever it is.
No, Your Honor, because it says lease, use, or occupied. Lease, use, or occupied. So there are three. There
So
are
it's
three.
disjunctive.
Right. There are three. Yeah. Lease, use, or occupancy. So
So why, given that it's framed disjunctively, would we think that the legislature sought to adopt the use and occupancy language of real estate law?
Precisely because if they intended for the word use to be applied to any right in property, such as an easement or a license, they would have said that in the statute. If they would not, as I think one of the MHE put it, the legislature doesn't hide elephant in mouse holes. So it didn't intend for the word use to have this broad meaning outside of what the word use typically means when it arises in between the words lease and occupy. Leased, used, and occupied. So that's why the court shouldn't focus on the word or, it should focus on the word lease, use, occupy, not the word or.
That's really stretching. So we're not supposed to look at the word or.
No, I'm sorry, should not give the word or meaning over, give that heightened meaning over the words lease, use, and occupy.
Well, but or means 1, 2, or 3, any one of those 3 things. I mean,
Right.
that's just what or means. I don't understand.
Oh, right, Your Honor. So for instance, if there was a storage facility that a for-profit entity was using, that would be that would be possessory interest in land that's not occupied, it's not leased. That's why the or exists, to cover situations like that.
Okay. Any other questions? Thank you so much. Okay, Attorney Ambriano.
May it please the court, Anthony Ambriano, on behalf of the Board of Assessors of the City of Boston. The court has questioned my brother extensively with respect to use and the terms of the contract agreement between Outfront and the MBTA. There's one additional point that I would like to emphasize, is that under that agreement, the proceeds go to the MBTA after all expenses are paid by Outfront. It is a net agreement to the MBTA. Furthermore, the agreement specifically says that in the event that any taxes are levied, those taxes are the responsibility of Outfront.
Can you finish your thought on that first part? What do you mean these proceeds are net to the MBTA? I don't.
Well, to clarify that point,
Thank you.
the MBTA wanted and received a minimum annual guarantee payment. That payment is received by the MBTA regardless of any expenses. On top of that, the MBTA gets a share of the gross. It participates in the gross revenues, not after the expenses are paid.
Okay. So what was your first point then? I don't understand.
Well, the first point is that it's net to the MBTA after the expenses are paid by Outfront. Perhaps I wasn't clear, but that was the point. The MBTA participates in a high revenue number.
What difference does that make?
I think the difference that it makes is that it was contemplated under this agreement, which was then entered into after the amendment to the statute. And that what the
That's just, you know, the lawyers, we don't really care what the MBTA's lawyers and the Ogden lawyers, I'm not sure how important that is. Help me out here. Ogden involved use too, right? Ogden, you know, I am troubled by what are the limitations of use? Because Ogden, you know, let the private company use its the University of Massachusetts let the private company use the facilities, right? I mean, so there's some limitations. I understand how we distinguish Ogden, but I'm trying to understand how we distinguish Ogden on the meaning of the word use.
I think in two ways. First, I'm just going to go backtrack just a little bit and point out that Ogden was under a different statute, 59(2)B. A crucial difference in that statute is that while it does make taxable certain property of the Commonwealth and its municipalities and its agencies that is used for profit. There's an important exception in there that has to deal with properties that are used for a public purpose. So even if a property under 2B might otherwise be taxable, if the purpose is, if it's for a public purpose, that property remains exempt. That is not the case under the statute we're talking about here today, Section 24. That public purpose language was not imported into this statute. I would point out then, perhaps more directly to your question, Justice Kafker, Ogden was paid by UMass. They were paid to manage the property. All profits and losses in that case went to UMass. Specifically in that scenario, if there was any tax liability, the tax liability was paid by UMass. So I agree it's very much a question of fact. It's a very fact-intensive determination that must be made.
You're saying UMass paid the tax liability in Ogden?
If there was any tax liability under the agreement between UMass and Ogden, UMass would pay it.
I thought 59 to be taxed the user. You're saying there was compensation, indemnity under the contract?
Yes, that,
Okay,
I
but
think
we're
indemnity
interpreting
is a
this,
proper
we're interpreting
word.
the statute, right?
Correct. However it might fall, however it might fall, if there was anything, it was UMass's burden, not Ogden's. So I think that's one of the
Could you
very
argue that the
important
same
differences.
thing is happening here, though? If we say that this relatively new provision covers out front, thank you, out front, I mean, in some ways it's affecting the MBTA.
In some ways,
because-
it may or may not affect the MBTA. What we
Well,
have here,
certainly it would, because no rational third party would contract with the MBTA if we construe the use the way the board is suggesting without getting something from the MBTA in return. Isn't that exactly what your opposing counsel's argument is?
well, I think what Outfront is getting in return is the exclusive right to make profits from the signs. That's what they're getting, and
But the MBTA is also making profits from the signs.
that is correct. And the terms of this agreement,
So it's not exclusive. It's what's good for us is good for the MBTA.
it's exclusive in the sense that only Outfront has the right to place advertising on those signs. That's what I meant by exclusive.
And how is that different from the management services being provided in Ogden? Only that entity could provide the management services, right?
Yes, that is correct. And the management
The
service,
exclusivity doesn't really make the difference. What does?
well, I think for one thing, it's very important that Ogden was paid by UMass. They were paid to render a service. And that service was managing it, taking care of it on behalf of UMass, which ultimately UMass was
Is that
for
really?
lack of a better legal term,
I
they
mean-
were in charge.
Sorry to interrupt you. Isn't in some ways Outfront being paid by the MBTA in the form of it? If the MBTA ran these signs, it would take all the money for themselves, but instead it's hired Outfront to do it, and so Outfront's payment for doing that is the profits that it reaps.
I think that is all correct. And part of that agreement,
So the difference between Ogden and Outfront can't be payment to the service provider.
well, I think,
Is the difference?
well, for one thing,
Isn't it the difference, the effect of the taxes?
I think that's a
Because in
large,
Ogden,
Well, isn't that what we're here to determine?
right, but in Ogden, the agreement expressly said UMass, if there are taxes, UMass has to pay them, right? Here, if they're taxes, both sides will lose out on revenues. Is that right, or am I misstating the
Well,
facts?
not both sides, not the city, but,
Well, the both sides, the MBTA and Outfront, if there are taxes, both will suffer negative consequences of that, right?
no. The MBTA will not suffer because the taxes are so,
Get less revenue.
I'm sorry?
They're going to get less of a cut of the revenue, right?
Well, I think we would have to,
You're basically transferring some money to the city that would otherwise go to the state.
or would otherwise go to Outfront. That's really the question. The legislature
Right, because
has determined.
the MBTA's profit from this agreement is a fixed fee plus a percentage of gross revenue from which the taxes would not be deducted.
Correct.
The problem with the argument that you have is the next contract that the MBTA enters into, which is, in that the next contractor for services will say, hey, look at Outfront. We were supposed to not get taxed on our use of the real estate, and somehow we're being, taxed. The next vendor will say, MBTA, you're in it with us then.
I don't know why either the MBTA or Outfront would have gotten into this contract and worded it the way they did, in particular with respect to taxes, if they did not expect to be taxed.
Is that relevant to our construction of the statute, the expectation of the parties going into the contract?
No.
Okay, so what is relevant? Tell me, what is it that makes Ogden different from this case?
I think it's the factual determination by the Appellate Tax Board, which obviously decided the Ogden case as well.
Can I ask you two examples, perhaps? If I'm operating a Dunkin' Donuts in South Station, right, under your view, that clearly comes under this exempt. It's exempt from the exemption, right? It's an exception to the exemption, right? That they're taxed. The Dunkin' Donuts is taxed. If I'm South Station, the MBTA, and I hire a custodial service to clean the bathrooms in South Station, are they taxed as well, the custodial service?
I think that would be a very far.
Is that a use of the real estate?
I think it'd be a very far stretch, and I think one point of the
Okay, so what's
statute
the
that we
difference
haven't
between
mentioned yet.
What's the difference between the custodial service and the Dunkin' Donuts?
For one thing, the tax is assessed, and this has not been addressed so far, as of January 1st to the user, lessee, or occupant as of that date. That suggests to me, and the contract here with Outfront goes until, I think, 2034, 2036. That I would consider a transient type of a use.
But isn't Justice Gaziano's hypothetical useful in saying Ogden is more like the cleaners? They're getting a flat fee to provide a service to clean the facility, and they're not getting a percentage of the profits of the facility. They're like UMass is running because they're not getting any money except for a fee. But here, Outfront they're engaged in a profit-making enterprise where they can, make as much money as they possibly can from those signs. It's not a set fee. They're different from the janitor. So the thing is informative. One's more like a janitor, not quite like it, but similar.
I think that is all true, and again, I focus on the exclusive rights.
But I'm looking at your definition of use in the Appellate Tax Board decision that's very broad, whether it does, in fact, apply to a custodial service, for-profit custodial service.
I don't think it would go that far because of the fact the ATB went through great lengths in its factual findings. It talked about the exclusivity, which I think was a very important
Okay,
point.
so I run Acme Custodial Services, and I got the whole of South Station. What's exclusivity have to do with it?
Well, I think it would have to do with the fact that the exclusive right is to hire other people to do it.
I got a fleet of janitors.
Well, that might be the case, but again, as of January 1st, what was going on as of January 1st. And I think that that notion very much implicates a time element, an element of some permanence. Someone who walks across a couple of times a year would not be found to be a user.
But what if I have Acme and I have a, 10-year contract to clean South Station? It's permanent?
Well, again, I think that would be more akin to Ogden than it would be to Outfront.
Could you address before you leave the burden of proof issue?
Yes, very much. Thank you very much for that opportunity. With respect to the burden of proof, in answer to Justice Wendland's question, there has been no case ever where the burden of proving an exemption, even an exception to an exemption, has been placed on a municipality.
Are there cases going the other way, though, or are we just writing on a blank slate?
I think A and B Fund addressed it with respect to property of Massport. I think it was also addressed in the South Station case, which I think ultimately gave.
The burden of proof, because the burden of proof issue was directly addressed, because, or we're going to get guidance on that?
Yes, it was addressed in both the A and B Fund case and in the South Station case, which is mentioned in the brief, at least in my opinion, the city's opinion, gave rise to this amendment to the statute.
A and B case is an appellate tax board case. Do we have any appellate cases providing guidance?
I think both the appeals court decisions of both A and B Fund and Beacon South Station Associates.
So in Beacon, there wasn't an exception to the exemption in the other case that you mentioned, A and?
Yes, A and B Fund, which is a Massport case.
And was there an exception to the exemption in that case?
Yes.
Okay, and we said that the burden, or the court said the burden is on the taxpayer?
Correct.
Okay.
If there are no further questions, my time is up. Thank you.